Welcome to Bond University on iTunes U.
And I'm sure that you will find it very gratifying that I use that brief form of salutation rather than the alternative way in which the first people of New Zealand greet others. If I followed that course of action, I'd be obliged to rip off my shirt and perform a haka. And the thought of me exposing my torso to you would probably ruin forever relations between Solicitors-General for New Zealand and Solicitors-General of Australia. I use the description for New Zealand because that's what is on my warrant. The role of Solicitor-General for New Zealand has evolved into arguably the most fascinating and challenging position that any lawyer in New Zealand can enjoy. And as I hope to demonstrate, the role of Solicitor-General in New Zealand can be divided into 5 distinct functions. The Solicitor-General for New Zealand is the Chief Executive of the Crown Law Office, the Principal Counsel for the Crown in New Zealand, Principal Legal Advisor to the Crown in New Zealand, Supervisor of the prosecution of indictable crime, and has a wide range of constitutional and other law officer functions. It will be immediately apparent that the role of Solicitor-General for New Zealand is broader than the role of Solicitor-General in the Commonwealth, the states and the territories of Australia. It is also quite different from the role of Solicitor-General of England and Wales, the United States, or the role of Solicitor-General in Canada, prior to that office disappearing from the Canadian government's lexicon in 2005. I had intended to divide today's address into 4 parts, but I'm going to change it. The first I will deal with concerns a brief overview of the history of the Crown Law Office and the role of Solicitor-General in New Zealand. The second concerns the current roles of the Solicitor-General in New Zealand. I was going to do some comparisons, but in this audience I don't think that's necessary. Instead, I think I will explain how today Solicitors-General are appointed in New Zealand, and then perhaps most contentiously I will advance some reasons as to why I believe that there are some advantages to the way the role has evolved in New Zealand. It will be seen, I hope, that the role of Solicitor-General for New Zealand is inextricably linked to the development of the Crown Law Office in New Zealand. In New Zealand, Walter Reid is rightly regarded as being the first non-political Solicitor-General. He was, however, not the first to be honoured with the title of Solicitor-General for New Zealand. That distinction belongs to the enigmatic John Hyde Harris. I think I have a photo of him. Yes, I do. What I'm about to tell you, I hope provide you with some degree of reassurance that not all of the characters of the 19th century legal communities resided in Australia. John Hyde Harris was Solicitor-General for just 6 months. In a brief biography in an encyclopedia of New Zealand, it's recorded that Harris was appointed a judge of the District Court in 1858 until that office was abolished in 1862. The following year, he became Superintendent of the Otago Province, where he incurred the wrath of the public of Dunedin when he dissolved the Dunedin Town Council. At the same time, he managed to incur debts of some £28,000 through speculating on the gold boom in central Otago. And after resigning as Superintendent of Otago, he joined the Stafford Ministry and served as Mayor of Dunedin while simultaneously holding office as Solicitor-General for New Zealand. He died in prison as a debtor. Sir Anthony, I hope he wasn't the relative that inspired your mother to send you on a course of law. I've got 14 more to go. At the time that Harris was Solicitor-General, New Zealand had a non-political Attorney-General. And the reason for this was that the Attorney-General's Act of 1866 provided that the Attorney-General had to be a barrister and solicitor of the Supreme Court and that no Attorney General was capable of being a member of the Executive Council or of either the House or the General Assembly. At that time, New Zealand had two houses of Parliament. It was during this time that Sir James Prendergast served as a non-political Attorney General. He was appointed Attorney General in 1867 and retired from that office on the 31st of March 1875 when he became the country's third Chief Justice. And it was during Prendergast's term as Attorney General that the Crown Law Office was established. This occurred in 1873 when the judicial branch of the Colonial Secretary's Office was divided into two new and independent departments of state, the Department of Justice and the Crown Law Office. When Prendergast became Chief Justice in 1875, Walter Reed was appointed Solicitor-General and head of the Crown Law Office. When Walter Reed was appointed, the following statement appeared in the Otago Daily Times. I think you can probably read that. Possibly no one else was more surprised at the series of accidents which placed him in his present position than Mr. Reed himself. Certainly neither his ability as a lawyer nor his skills at the bar could have ever raised him to it. The appointment was one with which the profession could scarcely approve of. I've endeavoured to find out who might have been the author of those rather unflattering words, and although I can't be absolutely certain, I'm reasonably confident that they have the style of one Mr. G.B. Barton, a quite disaffected Irish barrister who arrived in New Zealand from Victoria and was a contemporary of Prendergast's. Barton's greatest claim to fame was being imprisoned by Prendergast to a month in prison for contempt for daring to question Prendergast in quite respectful terms during the course of Prendergast giving an oral judgment. Notwithstanding this very inauspicious reception, Mr. Reed served as Solicitor-General for 25 years, by far the longest serving of the country's 15 Solicitors-General. It's worth noting that the Attorney General's Act was amended in 1876 to permit the restoration of the office of Attorney General to its proper position as a legitimate prize for lawyers who enter into political office. It was also at this time that the Crown Law Office, in its fledgling state, moved into new premises on the first floor of the government building, which many of you will know now to be the home of Victoria University's Law Faculty. Notwithstanding the existence of the Crown Law Office, prior to 1910, there was no central organisation for the control of the Crown's legal business. Every government department was, in this respect, autonomous, instructing and paying without supervision barristers and solicitors in private practice. In 1910, the year when Professor Salmon was appointed Solicitor-General, the legal business of the Crown was centralised into the Crown Law Office, and most departments were required to have their legal work done either by that office or by district Crown solicitors with the approval of the Solicitor-General. It was also in 1910 that the Law Drafting Office was absorbed for administrative purposes into the Crown Law Office. As this very brief summary illustrates, the origins of the Crown Law Office can be traced to a time of quite considerable uncertainty about the role of the Solicitor-General and the Attorney-General in our constitutional framework. Similarly, the role of Crown Law evolved from an office which was in many respects akin to a modern-day Attorney-General's department into an independent government department which ultimately was responsible for the management of most, if not all, of the government's legal business. The appointment of Sir Richard Wilde as the country's 9th Solicitor-General in 1957 heralded a series of changes to the way in which the government's legal services were delivered. These changes became apparent when the Cabinet rules for the conduct of Crown legal business were published in the Gazette in 1958. I won't go through the details, but it's fair to say that under Wilde's stewardship, the Crown Law Office became the undisputed focal point for almost all of the government's legal work. In 1966, Wilde became Chief Justice. In 1988, New Zealand's public sector underwent significant change. The State Sector Act of 1988 was the catalyst for the establishment of a range of autonomous government departments and agencies. A consequence of these changes was that the Crown Law's vice-like grip in over the government's legal services loosened just a little. The then Solicitor-General, now Sir John McGrath, revised the Cabinet rules for the conduct of Crown legal business in 1993. The new rules endeavoured to strike a balance between ensuring the Crown Law Office received the Crown received legal advice and representation of the highest possible standard, while at the same time ensuring Crown Law no longer enjoyed the virtual monopoly that had previously existed in relation to government legal services. The Crown directions for the conduct of legal services in 1993 divide legal work into two categories. Category 1 consists of 5 classes of work, which I have put up on the screen. This is tied work, and a number of Crown solicitors in Australia will be familiar with regimes of this kind. All of this work must be referred to the Solicitor-General and is invariably conducted within the Crown Law Office. Category 2 work is open to competition, and what I've found particularly pleasing over the last 5 years is that the proportion of the Category 2 work, which is conducted by Crown Law, has risen very significantly, so that now Crown Law is the second largest provider of Category 2 work in New Zealand, and I find that particularly pleasing because we don't do transactional work. So a very large proportion of all other work which departments and Crown agencies can go to the private sector for is actually now coming into Crown Law. I will now deal with the current roles of the Solicitor-General for New Zealand and start with the Chief Executive of the Crown Law Office. The Solicitor-General is not appointed pursuant to any particular statute. There is no Solicitor-General's Act in New Zealand, although the title is referred to in a number of pieces of legislation. Under Section 44 of the State Sector Act, the Solicitor-General is the Chief Executive of the Crown Law Office. However, unlike other Chief Executives, the Solicitor-General is appointed by royal prerogative and not under the State Sector Act. Consequently, the warrant appointing the Solicitor-General provides that the appointee holds office at Her Majesty's pleasure and will. It's impossible, in my view, to reconcile the terms of the prerogative appointment with the practice which has developed quite recently, whereby the appointment of the Solicitor-General is for a fixed 5-year term. The terms of the prerogative must prevail over the fixed term arrangements which have been recently introduced. While the Solicitor-General is not accountable under the State Sector Act, he has the responsibilities of a Chief Executive under that Act, including ensuring Crown Law complies with the Public Finance Act. Crown Law is, as I mentioned earlier, been an independent Department of State since 1873. In my view, Crown Law's independence is essential if it is to continue to provide the free and frank advice which ministers and departments require, without there being even the perception of constraint by way of managerial control from a larger department. Crown Law's independence also goes a long way towards explaining why it has continued to attract lawyers of the highest calibre to its ranks. Crown Law is a small government department. It currently has 106 lawyers and 92 support staff. The day-to-day management of the Crown Law Office is overseen by a practice manager, and as you would expect, the office is organised into management teams and workflows, ultimately under the supervision of the Solicitor-General, but in reality the 3 Deputy Solicitors-General play a very active role in the management of the office. The Solicitor-General's powers may be delegated and are delegated under Section 9C of the Constitution Act to the Deputy Solicitors-General. I'll now deal with the role of Principal Counsel because, in my view, this is the most pleasurable aspect of the role of Solicitor-General. In his seminal publication on the role of the Solicitor-General, published in the 1997 New Zealand University's Law Review, Sir John McGrath noted that Solicitors-General are appointed from the ranks of experienced barristers of the profession and either working in private practice or the Crown Law Office at the time of appointment. The person appointed is thus an experienced legal advocate and advisor. At a practical level, the volume of litigation facing the Crown means that the Solicitor-General has to be very selective when determining what cases he, and so far it has only been males who have held this office, what cases he will personally conduct. The establishment of the Supreme Court in New Zealand in place of the Privy Council in 2004 has meant that the Crown Law must now manage a far higher workload of a final appellate court litigation than when New Zealand's appeals were to the Privy Council. By far the greatest increase of the appellate workload has been in relation to criminal appeals. The Supreme Court now hears in 1 year as many criminal appeals as the Privy Council heard from New Zealand from 1840 to 2004. Between 1840 and 2004, the Privy Council heard 12 substantial criminal appeals from New Zealand. It allowed 4 of them, and as it transpired, I was counsel in 2 of them, one when I was in private practice and was one of the ones that succeeded, and as luck would have it, as soon as I became Solicitor-General, I had the ignominy of losing one in the Privy Council. But in Wellington now, the Supreme Court has heard 52 substantive criminal appeals since its establishment and has dealt with over 319 criminal leave applications. So just in relation to criminal appeals alone, the workload of the Solicitor-General and the Crown Law Office has escalated quite dramatically. I will now move on to dealing with the role of being principal legal advisor to the Crown. The Solicitor-General is the government's principal legal advisor. He's not, of course, the only legal advisor. Ministers, including the Prime Minister, regularly take advice from within their own departments. The Solicitor-General is, however, the arbiter of conflicting views of the law within government, and for this reason, ministers and chief executives do not hesitate to seek the views of the Solicitor-General quite literally at any time. Often the advice sought is informal and it's not recorded, and normally takes place, in my experience, between about 9 and 10:30 or 11 o'clock on a Sunday night or a Monday night, which is when ministers seem to be at their most active, and is designed to assist busy ministers and chief executives to reach their own independent conclusions on an issue of concern. When, however, formal advice is sought, Crown Law prepares opinions either directly for the Attorney-General, in the case that is provided for ministers, or for the department concerned. All advice is, of course, subject to legal professional privilege, and that privilege can only be waived by the Attorney-General. The role of Crown Law opinions is to provide perceptive, objective, and practical and authoritative statements of the law that apply to issues arising in the course of government. The requirement for objectivity means that Crown Law opinions should reflect the particular needs of the minister and departments, as well as the wider Crown interests in any particular case. This places considerable pressure on Crown Law, particularly when the advice which they're being required to give is being paid for by a department that may not actually like the fact that the advice needs to be given in a way that reflects not only their interests, but the wider Crown interests. In the paper, I make reference to the observations of the recently retired Secretary for Cabinet, who noted from her practical experience that from her point of view as Cabinet Secretary, and I'm quoting now, "I saw on many occasions when the Prime Minister, Attorney-General or Cabinet Secretary was obliged to call in Crown Law where legal advice was absent, patchy, self-interested or otherwise questionable. The moral of that story being that departments who attempt to circumvent obtaining advice from Crown Law risk undermining their own credibility and ultimately increasing their costs if they obtain legal opinions that lack the authoritative and public interest perspective offered by Crown Law." Supervisor of the prosecution of indictable crime, Rob, I do issue indictments and do so on a regular basis. By convention in New Zealand, it is the Solicitor-General rather than the Attorney-General who is ultimately supervises the prosecution of indictable crimes following committal. The police, of course, and other prosecuting agencies have the discretion to bring charges subject to specific statutory exceptions, but following committal, the responsibility for the conduct of criminal proceedings rests with regional Crown solicitors as agents of the Solicitor-General. The convention, which has developed in New Zealand and which has resulted in the Attorney-General playing virtually no role in the prosecution of criminal cases, ensures that no perception of political influence exists whenever an issue arises that requires the attention of the Solicitor-General. The Solicitor-General or his delegated deputy plays a direct role in decisions to stay prosecutions. The power to stay prosecutions is found in Section 378 of the Crimes Act, and it is from this and other statutory powers that the ability to provide immunity is derived, whereby the Crown promises to stay any future prosecution in defined circumstances. The only significant case in New Zealand's recent history in which the Attorney-General took personal responsibility for the stay of a prosecution concerned the aftermath of the Rainbow Warrior case. In 1991, following the arrest in Switzerland of a French citizen wanted in respect of the 1985 bombing of the Rainbow Warrior, the Attorney-General personally stayed all outstanding charges against that French citizen. He did so on the basis that he was able to make a decision that took into account New Zealand's wider international obligations and interests, including its future relationships in striking trade deals in Europe. The Solicitor-General or his delegated deputy is also directly involved in all criminal appeals brought against conviction or sentence in the Court of Appeal. Under Section 390 of the Crimes Act, the Solicitor-General is required either personally or by his representative to appear in every criminal appeal. Similarly, decisions to appeal sentences by the Crown on grounds of undue leniency or the wrong application of principle are made by the Solicitor-General or a designated delegate. I'll now move on to the fifth category of work, constitutional and law officer functions. The Solicitor-General discharges a number of miscellaneous constitutional and other law officer functions, three of which I'll mention just at this juncture. The Solicitor-General plays a coordinating role in relation to the appointment of Queen's Counsel. Candidates for silk are required to forward their applications to the Solicitor-General, who provides an interface between the Attorney-General and the Chief Justice and the profession during the appointment process. The Solicitor-General provides a similar role in relation to the appointment of senior judges, that is, judges of the High Court, Court of Appeal and Supreme Court. And touching on Michael's paper, the Solicitor-General also provides advice directly to the Governor-General on a variety of constitutional and legal issues, particularly during the formation of a government following a general election. There are, in addition, approximately 70 statutory duties conferred on the Attorney-General and Solicitor-General. The duties and powers conferred on the Attorney-General may be exercised by the Solicitor-General pursuant to Section 9A of the Constitution Act, but interestingly, the converse does not apply. Section 9A of the Constitution Act, which has been in earlier statutes since 1875, provides that the Solicitor-General may perform any function, power, or duty that rests or is vested in the Attorney-General. And the Attorney-General doesn't have to be absent for those powers to be exercised. So it is a power-sharing arrangement, and one that Sir John McGrath spent some time writing about. As you can imagine, the relationship is one that has evolved over time, with some very interesting conventions and practices developing that have developed as a way to ensure that those power-sharing arrangements work effectively. The powers and duties conferred on the law officers cover a myriad of functions. These include authorising prosecutions, such as prosecutions under the International Crimes and International Criminal Court Act, Terrorism Suppression Act, being the protector of charities, and being on various statutory bodies such as the High Court Rules Committee and the Council of Law Reporting. I had at this stage intended to talk about some international comparisons, but I'm going to skip that section entirely, and thought that in light of what Martin said about his appointment, I would explain how a Solicitor-General is appointed in New Zealand, or at least how it's happened most recently. As in Victoria, the position was advertised publicly, and maybe that will be the steps that are followed in Western Australia soon. Applicants put in their curricula vitae and fill in forms, and the selection process was under the management, but not ultimate authority, of the State Services Commissioner. I'm trying to think of an Australian equivalent of the State Services Commissioner, an independent statutory body that is responsible for the appointment of chief executives of government departments. Public Service Commissioner. Okay. 4 Queen's Counsel were shortlisted, and then the fun really began. And the fun commenced with a requirement that I undergo a cognitive screening assessment, which involved me having to sit a series of tests over the space of about 2 hours. A lot of these involved very quick mathematical calculations, which I thought would equip me brilliantly for being an advocate or a legal advisor. I was also required to identify what I could see in certain patterns that were flashed up in front of me, which I also thought would be incredibly helpful when appearing before their honours. After that process, anyone left standing then had to undergo an evaluation from 2 clinical psychologists. Now, I confess that this aspect of the story reflects quite adversely on my character. I actually enjoyed that part. And I don't know why. And then the interview commenced after that, before an interview panel comprising the State Services Commissioner, the Chief Executive of the Department of Justice, a retired judge, and a senior barrister. That process finished in July 2006, early in July 2006. My wife and I were on holiday in Barcelona in mid-August of 2006 when the phone call came through asking me to accept the position, which I did. It is only recently, like in the last few weeks, that I found out why there was such a significant delay. It transpired that there was a lot of consideration being given about splitting up these various roles which you see on the screen. The perceived wisdom being no one in their right mind should be forced to have to do all of these jobs. And they probably worked out that I wasn't in my right mind, so therefore I was eminently qualified to do it. I would now like to just move on to one final part, and that is to discuss what I perceive, and I don't mean this to be provocative in any way whatsoever, but what I perceive to be the advantages of the way the roles of the Solicitor-General and Crown Law have evolved in New Zealand. I start with 3 observations. The first is, and this is where I take perhaps mild issue with Keith Mason's observations this morning. The first is that the Crown can have only one view of the law. Ministers, chief executives and others in government who are dependent upon legal advice need to receive just one explanation of the law. That explanation must of course be authoritative and it must be right. This contrasts with policy advice. Ministers and other senior decision makers within government seem to me to relish competing policy viewpoints. Competing policy advice really enables ministers and other decision makers to shape and influence the ultimate policy outcome. But ministers and senior decision makers cannot and never should influence or shape the explanations as to what the law is in order to try and achieve their objectives. The second observation I make is that, like Australia, the growth and the compartmentalisation of government in New Zealand has resulted in the creation of a large number of government legal departments. There are currently in New Zealand's small community 756 lawyers employed in government in Wellington, employed by 37 departments and government agencies, and the costs of providing this service is considerable. In the last financial year, we have calculated that was 181 million, and approximately half of this was spent on external providers, including Crown Law. Crown Law is categorised as an external provider for these purposes. The third observation I make is that the creation of a large number of autonomous government departments since 1988, many with their own significant legal departments, has increased the risk of government lawyers providing competing advice to decision makers, and in circumstances where it is very difficult to assess the quality of that advice. However, notwithstanding these potential risks, the position in New Zealand does not appear to have reverted to the dire state which Sir John Salmon encountered when he became Solicitor-General in 1910. When he took office, government legal departments appeared to be acting entirely autonomously with little or no regard to Crown Law. Was it Sir John Salmon who inspired you? Oh, right. You had me guessing. My observations of the way in which the role of Solicitor-General has evolved in England and Wales, Canada, the United States, Australia and New Zealand is that the current roles of the office in New Zealand suit the needs of our small country well. In particular, I think that one of the strengths of the Office of Solicitor-General in New Zealand is the way in which it is inextricably bound to the Crown Law Office. In my assessment, the Australian position, which has seen the creation of clear lines of separation of responsibility between Solicitors General, Crown or government solicitors and directors of public prosecutions, would, if adopted in New Zealand, weaken rather than strengthen the constitutional importance of the Crown Law Office and the Office of Solicitor General. And my reasons for saying this can be briefly stated. There is considerable advantage in having the Solicitor General actively supervise and oversee the advice and representation which the Crown Law Office provides. By actively participating in the day-to-day business of Crown Law, the Solicitor General is able to minimise the Crown's legal risk. I endeavour to ensure that the Crown's trial and lower court litigation is managed in a way that doesn't compromise the Crown's position if the case should proceed to the Court of Appeal or the Supreme Court. If the Solicitor General were not part of the Crown Law Office and received instructions to appear, say, at appellate level only, there is a risk that the opportunity for strategic planning of the Crown's litigation would be diminished. Secondly, by heading the Crown Law Office, the Solicitor General is also able to identify those cases which require his or her immediate attention. While I'm sure that a conscientious Crown Solicitor or head of a Crown Law Office who wasn't the Solicitor General would work constructively with an independent Solicitor General, the risks of a breakdown in communication do not exist if the Solicitor General has direct control over the cases being managed within the Crown Law Office. Thirdly, Crown Law has the unique advantage in having the Solicitor General as its head. All staff in Crown Law know that they can enlist the assistance of the Solicitor General literally at a moment's notice to assist in the management of a file or Crown Law's relationship with a government department or minister. Removing the Solicitor General from the Crown Law Office risks undermining Crown Law to the point where it would be almost indistinguishable from the legal sections of regular government departments. I also believe that the Solicitor General and Crown Law should continue their roles as the principal law officers who both advise and represent the Crown on litigation. In my experience, there is considerable advantage to one organisation providing a whole-of-government approach to the advice they give ministers and key decision makers, and who can take finely tuned public interest considerations into account in the way that litigation is conducted in the name of the Crown. This approach works particularly well in the New Zealand context, where there is a fused profession and where, as a consequence, very highly qualified lawyers in Crown Law provide both advice to and representation services for the Crown. For similar reasons, I see considerable merit in the current New Zealand system whereby the Solicitor General provides oversight to the prosecution of indictable crime and brings public interest considerations to the forefront of his mind when making decisions about staying prosecutions, granting immunities, or authorising the bringing of prosecutions. In my experience, those decisions are best made by those who do not have a direct interest in the investigation or the prosecution of particular cases. There are, however, many ways in which the New Zealand system can and should be improved. The creation of legal teams within autonomous government departments and agencies creates risks which I have previously referred to. New Zealand does need to take steps to ensure greater cohesion between lawyers in government departments and the Crown Law Office. Lawyers in government departments frequently need to be reminded of their constitutional responsibilities to the law officers of the Crown and to appreciate the roles and functions of the law officers. This need will, in my view, to a large extent be addressed through the creation of New Zealand's Government Legal Service, which is loosely modelled on the Government Legal Service managed under the auspices of the Treasury Solicitor in London. The New Zealand Government Legal Service is in the process of being established, and once created will ensure that chief executives have access to a resource to assist with the recruitment and appointment of lawyers in government departments. There will be a resource to assist in the training and development of lawyers in government departments. There will be a resource which will be able to assist in the rationalisation of legal information services and law libraries within government departments, and it will provide a focal point for coordinating the way in which lawyers in government respond to issues that are common to government departments. In conclusion, can I make the following remarks? The evolution of the role of Solicitor-General can, as I have previously mentioned, be traced to a period in our colonial government where considerable uncertainty existed about the roles of the Attorney and Solicitor-General. Since 1875, the role of Solicitor-General has developed in a way which is unique to New Zealand and reflects the country's small size and comparatively flexible constitutional and political structures. It also reflects New Zealand's unitary legal profession. But before I conclude, I should acknowledge the obvious. The role of Solicitor-General is undoubtedly very challenging. It is, however, manageable, provided the Solicitor-General has appropriate levels of high-calibre support. And it has definitely been my pleasure and privilege to be supported by some of New Zealand's most talented lawyers who have foregone the benefits of private practice to play significant roles as advisors to and representatives of the Crown in New Zealand. It has also been an enormous pleasure to be associated with the Solicitors-General of the Commonwealth and the States. Whilst I don't attend all of the Solicitors-General meetings, I try to get to at least one a year, sometimes two. And it has been a great source of support to know that people are only a phone call away who do understand something of the role that I have to perform in New Zealand. And I was particularly grateful to Walter Sofronoff, and I'm sorry he's not here to be able to hear this, who was willing to accept arguably the most toxic brief that was going in New Zealand last year when he agreed to take up the unenviable role of prosecuting a Supreme Court judge before a judicial conduct panel. Thankfully, the judge in question resigned before it got to a hearing. But Walter was willing to do that and partially justified it on the basis that he considered that his ability to be able to have a right of private practice enabled him to accept those particular instructions. Thank you.
I advise all my students not to use PowerPoint. What are you going to do if the PowerPoint goes wrong, and so forth and so on. So and you'll see from some of my charts, I'm not particularly good at this. I'd like to say that I'm at the after lunch session for a reason, to wake you up and have a lot of stimulation here. But one's always, as a professor, reminded of that teaching evaluation that you didn't want to see, that if you begin reading it where the student says, if I had but 5 minutes left to live, I'd like to live them in Professor Perry's class, because Professor Perry can make 5 minutes seem like an eternity. So no promises there. Having said that, I will, I think, be a little shorter than my time, famous last words for a professor, but I do believe that the other, you might find the panel discussion more interesting than particularly details about the United States. When one speaks at a conference outside of one's own country, it's always very difficult, because On the one hand, I don't want to tell you stuff you already know, and yet I often realize in my instance, I go abroad and I don't understand a lot or nearly as much as I thought I did. So I'm going to err with all apologies to telling you some basics about the role of the U.S. Solicitor General, and I hope some of it will come as news to you. I doubt that it will to Sir Anthony Mason. I've had the pleasure of meeting with him a couple of times, and I think he already knows more about the office maybe than I, as well as some constitutional law, but I hope there'll be some new information here. Also, as an educator, I wear two hats, as already suggested. I am both a law professor, I'm a very traditional law professor. I teach with the Socratic method, I do constitutional law, but I'm also a political scientist. And in wearing those two hats, one way that allows me to escape responsibility in either of my two jobs when I want to, but I can't risk coming to a group like this and really trying to raise and be a little bit provocative about some questions that I don't know if they will be on point or not. What I intend to do is raise some questions I have about what's going on in the United States with our own Solicitor General and with state Solicitors General, and whether or not you can see anything in that that may or may not be applicable to your situation as you think about it. I just don't know. But as an educator, I can't resist the temptation to come and learn a lot about things myself, and I already have. And I hope there'll be something here that learning about the United States Solicitor General might be applicable to your jobs. When a session of the U.S. Supreme Court begins, there's always a crier of the court who says, "Oyez, oyez, oyez, all persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God bless the United States and this honorable court." The person who's most likely to answer that call to come and pay attention in the United States is going to be the Solicitor General of the United States or someone from his office. Indeed, in recent years, that the person who responds to that call to speak before the Supreme Court speaks in about 75% of all cases argued in the U.S. Supreme Court. Either the Solicitor General or someone from his or her office speaks before the Supreme Court now in about 75% of all argued cases. And I should say, when I refer to the Solicitor General, I'm going to talk about both the Solicitor General as a person, but I'm largely referring to the office of Solicitor General. And I'll say something about that structure in a moment. Among those who care about serious appellate lawyering in the United States, for those who do care about that, no office in the United States holds more prestige than the office of the United States Solicitor General. Indeed, the lawyers in that office are among, if not the very best, appellate lawyers in the nation, and they are also among the most powerful lawyers in the nation. And yet, in some ways, they are all, and I don't know where to make this plural, eminence grises. Many people wouldn't know exactly who the Solicitor General is. And while one might expect that of the public generally, even lawyers might know the name of the Solicitor General, but they probably don't know the names of many of the powerful lawyers in the Department of Justice that serve in the office of the Solicitor General. And many of them really don't know and understand how that particular office works. So here we have these very important individuals. They remain largely unknown to the public and even many of the practicing bar. And yet, of course, to anyone who works in the Department of Justice or argues before the U.S. Supreme Court is well aware of the Solicitor General and the power of that office. And it has been, though there has been a fair amount written on the SG's office, it's still an office that is somewhat shrouded in mystery. I became interested in the Solicitor General's office many years ago when I did begin my work on the cert process in the U.S. Supreme Court. I was given the great good fortune to interview justices, their law clerks, and people around the Supreme Court to talk about the internal working processes. They'd not given those types of interviews to others before. They were a very cloistered institution at the time. And I kept hearing over and over and over about how important the Solicitor General was to the justices. Incredibly warm feelings of one branch of government towards another, saying how they couldn't do their work if it wasn't the Solicitor General. So that's something you can relate to, I take it, in one way. And so I thought, I really ought to look into this a little bit more. I then proceeded to begin working on studies later of the U.S. Department of Justice, and as a result of that, I interviewed many former Solicitors General, people who've worked in the office, people who've worked with the office, and so it's been a long-term interest of mine, and I appreciate Patrick Kaiser for including me in this, and partly because of my own interest, and partly because it gives me such a great opportunity to learn. And again, we'll see if I've got the right slide coming up. Let me start here with an outline of the U.S. Department of Justice. You don't need to see all of this, and I don't know how much of this is readable for you, but it sounds to me not dissimilar from what many of you have been talking about. This is the organization chart. It doesn't change very much from year to year, but you can see it was signed by our current Attorney General, Eric Holder. There's the Attorney General, the Deputy Attorney General, and then there is the Solicitor General on par with the Associate Attorney General, who is the head of the divisions. And what I'd like to point out some things about the organization of the department is I want to give you some sense of how complicated and important the Solicitor General's office is. Can you read that from where you are? I'm sorry, this was the largest. I knew how to make it. I'm going to have to step away from the camera just a little bit to be able to point some things out. If you look in the hierarchy under the Associate Attorney General, you will see the divisions to what is on the right side: Civil Rights Division, Civil Division, Antitrust Division, Environment and National Resources Division, Tax Division. That's the important divisions of the Department of Justice. They handle all of the aspects of these particular areas of federal litigation in the United States. I'll have a little bit more to say about them later. If you'll come over to the other side of the chart, after you get, let's skip the middle for a moment, you get down to the FBI, different things involved in the criminal division, which is another one of the litigating divisions. You have a lot of things like marshal services. And way down here, you get this thing called U.S. attorneys. In a bureaucratic hierarchy, they seem way down the line. But in fact, these are extraordinarily important figures. One that you might have heard of that was a powerhouse was a guy named Rudy Giuliani, who later, of course, became the mayor of New York and famed for 9/11. But the Southern District of New York is one of the most powerful U.S. attorneys' offices that exist in the United States. And other U.S. attorneys are extraordinarily powerful individuals, and they're powerful for many different reasons. One, they are presidential appointees that must receive the advice and consent of the Senate, just as the Attorney General does. Now, the U.S. attorneys are located in all of the federal districts in the United States, and they're the ones who start and bring federal prosecutions, involve representing the interests of the United States throughout the United States. And they have staffs, obviously, many of whom are civil servants or at least full-time employees. The United States Attorney is an appointed official, handles this particular work. But let's say he loses a case or she loses a case and wants to appeal it to the next level. He or she has to get the approval of the Solicitor General of the United States before he or she can be allowed to appeal the case that she lost. So normally what they will do is, depending on what the case is, they will have to begin working with what we call main justice in Washington, the people in D.C. in one of these divisions, whether it's an antitrust case or a criminal case or a civil case of some sort. So they then have to work with bureaucrats in the department. I shouldn't say bureaucrats. They are bureaucrats, but they're first-rate lawyers in the Department of Justice to talk about the nature of their case, and they will try to be shaped by one of these particular divisions. Now, again, in theory, they are superiors to the United States Attorney, but the U.S. Attorney, of course, is a presidential appointee, and as I forgot to mention, she or he also, to get that job, probably had to be sponsored by the home state senator in order to get that. So they are very powerful political figures, and yet they're fairly well down in the bureaucracy. They work through the divisions in main justice. Main justice in the civil division, criminal division may pick up the case, may become very much involved with it, but then, no matter how excited let's say the criminal division or the civil rights division is about taking this case and appealing the loss, it is a very small group in the Solicitor General's office who will wind up making that decision. And there you see the structure of the Solicitor General's office. There is the SG herself, and then there are these deputy solicitors general, and then there are the staff attorneys, and you can pretty much forget about the rest of the organization chart. Many of the deputy solicitor generals have been there for, if not the entirety of their career, for many, many, many years. Some 20, 25 years in the Justice Department, have argued dozens, hundreds of cases in the Supreme Court. And so now the head of the Civil Rights Division must go on bended knee, in a sense, though the SG wouldn't like me saying that, along with the U.S. Attorney, and ask the Solicitor General if they may appeal the case. And in many cases, in most cases, the Solicitor General will say, no, swallow hard, you're going to take the loss. That's not an easy job, as you might well imagine, in this particular context. There's a whole set of other people that matter in terms of litigation in the United States, and that is lawyers in the agency. So there's chief counsel in the Health and Human Services, there's chief counsel for the Army, there's chief counsel in every administrative agency, for the Federal Trade Commission, for all of these individual places, all having very intense interests. Health and Human Services loses a case, let's say about health care or so forth and so on. They desperately want to appeal this case. They still have to go to the Solicitor General. Anytime any government attorney in the United States is allowed to appeal any loss, they must officially have the approval of the Solicitor General and the Solicitor General's office. So it's not hard to imagine how very, very important this office is in the United States. And what helps it maintain its credibility is that there are just hardly any better lawyers in the United States than those people that exist in the office of the Solicitor General. And you can also imagine the political toing and froing that exist about seeking the ability to appeal. I did something back. How do I go back a slide? Do you know, just backspace? Up. Oh, I'm good. This is just the mission and functions of the SG, Office of Solicitor General, that's published by the Solicitor General's office. Nothing very surprising here, but it's the mission of the Office of Solicitor General is to represent the interests of the United States before the Supreme Court and to oversee appellate and certain other litigation on behalf of the United States in lower federal and state courts. Now, in reality, the Solicitor General or members of those offices rarely appear in any courts other than the Supreme Court, but they do from time to time, much to the displeasure of the U.S. Attorney who wanted to take the case, or maybe the head of the Civil Rights Division, for example. The major functions are to conduct or assign and supervise all Supreme Court cases, including appeals, petitions for and opposition to certiorari, briefs, and arguments. And I assume you know that the way you, in almost all instances, you go before the United States Supreme Court is by a petition for certiorari. The SG's office determines whether and to what extent appeals will be taken by the government, or whether the government will file a brief amicus curiae in any appellate court in the United States, or in any appellate court, actually, and determine when and whether the United States should intervene in any court to defend the constitutionality of an act of Congress. So that's the basic mission and functions, and that really is basically their job, although that's why I say they only respond to number A as opposed to B that you suggested, although I'm not sure I was reading that exactly correctly. But that's a pretty big job in and of itself. It's very important to note, though, in this mission, they do not serve to issue official legal opinions to the government. That is done, they did historically, but that is, for a long time now, that has been done by something called the Office of Legal Counsel. So when an opinion is issued by the Attorney General, it no longer comes from the Solicitor General, but it comes from the Office of Legal Counsel. And that is also, as you may have read about with our last president, there are all kinds of debates between the Office of Legal Counsel and White House counsel on all sorts of things that we cynical people might refer to as torture. And this is one of the things that got into another brouhaha with the idea that the advice that is being given to all different sorts of people, even including the president, there are lots of different lawyers, and the lines of responsibility, as I'll have something to say about a little bit later as it relates to the Solicitor General, is related to that. But their technical function is to only govern the appeals process. Now, oftentimes what happens is when the Solicitor General decides to take the appeal, the criteria that she or he is using, of course, is what are the interests of the United States generally. Like all good lawyers, you have some decision of what case to bring at an appellate level in different sorts of ways. You obviously want to bring the case that presents the fact situation and the best way to get the result that you might want. And so the screening function of the Solicitor General is huge, and they are often, of course, looking for cases that will most likely enable them not only to win, but to help develop law in the area that they think will apply in the best way to the United States generally, not necessarily to the Department of the Navy or to the Department of Health or Human Services. And so they screen cases with incredible care in terms of finding out what they think is the best interest of the United States generally. But they also are keenly aware of what the court's interested in, particularly the Supreme Court, and how they might help them in picking a case that would help them get to some of, say, constitutional or other issues that they might be looking for. So much of what they're doing is screening these cases and making decisions to serve the government and to serve their own interest in their client. Well, that leads us to the question, who is the client of the Solicitor General? And there are huge debates about this in the United States, particularly among academics. One Solicitor General said that actually he had 9 potential clients: the people of the United States, the federal government as a whole, the administration in which he serves, the president, which not always agrees with the administration, his own administration. He serves the Attorney General in some instances. He has responsibility to serve executive branch departments and agencies. Sometimes his clients are individual federal employees. Sometimes his client is an independent regulatory agency, which is, relatively speaking, not under the control of the president. And his client is also the Congress in order to defend laws of the United States, even though his appointing president may hate the law and disagree with it. So there are lots of different clients. Now, one former Solicitor General, Francis Biddle, said that, that the notion of a client to the Solicitor General is but an abstraction. But when we think about the idea of law and representing an interest in a court, the idea that the client is an abstraction is problematic as well. And the definite resolution of whom the Solicitor General serves is, I think, kept appropriately murky, both by the Solicitor General and many others that would have interest in being represented by the Solicitor General. Now, ultimately, as a constitutional question, he is appointed by the President of the United States and ultimately serves at the President's pleasure and can be fired by the President. So at some level, the basic responsibility is to the President. And yet in what I learned from many of, at least if I'm hearing you right, in many ways, the chief legal officer for the president is either his own White House counsel or is the Attorney General, who is a more political appointee, runs the FBI, runs all of these other types of services. And there is generally a hands-off attitude towards the Solicitor General and a belief that the office cannot become too politicized or be seen as pushing the president's wishes against all these other myriad interests of representing the United States. So the constitutional question may be ultimately responsible to the president, but the reality and the way it works is much more complicated, and I think that's probably a good thing. Now, it's not only the case that the Solicitor General has become has a very important role to play in the litigating in the legal structure of the United States generally, but this person and this office has become an extraordinary success. I've already suggested to you that they participate in about 75% of the cases before the U.S. Supreme Court. There are over 10,000 cases a year that seek review in the United States Supreme Court. The average acceptance rate is 3% of all cases that seek review in the Supreme Court. And yet, when the Solicitor General applies for review, she wins, or review is granted to her in 70% of the cases. It's an extraordinary figure compared to the numbers sought, the relatively small docket of the Supreme Court, and the rejection rate generally. Now, part of this has come about for some of the reasons I've suggested. They screen cases very, very carefully. They want to keep up their winning ways in the Supreme Court, and so that when they say, Madam Justice and Mr. Justices, you ought to take this case, they've built up enormous credibility over time, resisting bringing up all sorts of cases that might cause problem, and as a result, they're rewarded with getting 70% of the cases. Now, I don't want to overstate that because, of course, when you're representing the United States, your case is by its own nature very important. But, and so they have an advantage in the nature of the interest they're representing. But by any measure, particularly given the way the U.S. Supreme Court works, a 70% acceptance rate on certiorari is dramatic. But the success doesn't stop there. When the Solicitor General is the petitioner, they win on the merits 70 to 80% of the time they're arguing before the court. And this even goes across, though there is variation a bit, this is an average across courts and across solicitors general, so that even if you're representing a liberal administration in front of a conservative court or vice versa, the win rates are absolutely extraordinary. And maybe an even more extraordinary figure, because the court does tend to, the petitioner tends to win more generally, because when the court is taking up a case, there is some greater likelihood that they're going to reverse. But what's even more extraordinary about the U.S. Solicitor General is that they win 50 to 60% of the cases when they're respondents to the case. So if you happen to see the title of my talk, I refer to the Solicitor General Winning Ways. And I think it comes from lots of reasons. I've suggested the screening. They are amazing and excellent lawyers, but they're also repeat players. They know what works in the court. They know what doesn't work in the court. They know what the court's looking for. They are very, very sophisticated appellate lawyers, as I've already suggested. They also are known for their sheer and complete honesty and probity and no games with the court. The Supreme Court often will confess error in cases that the United States has won and agree with people seeking a judgment against the United States. Another lawyer can't do that, basically. You're not representing the interests of your client, at least in the United States. But they'll confess error and say we should have lost, and they will urge review perhaps in a petition for certiorari, or sometimes it gets handled in other ways. They never, or almost never, try to mislead the court. And the justices themselves know that they know that they are advocates, but more than every advocate can tell the truth and not mislead the court, but really try and turn it to the best advantage of your client. And the SG is very aware of, they never want to be accused of having misled the court down the wrong path in a way. Now, it's not that these guys, unlike you, have halos on, around them. They understand that as a repeat player, it is in their interest over time to have this extraordinary credibility with the court, meanwhile serving as advocates. The court does realize that there are certain times, political cases that a president may care very strongly about. And justices told me this. They said, the SG is not up there for 2 minutes before we say, oh yeah, the president absolutely insisted that they take this case. And they know that that's what the SG is having to do. Probably lost the battle with the Attorney General not to take the case and so forth. And they can see it. In fact, there was one issue as I was interviewing both the SGs and the court about this. As a political scientist, I was really interested in the extent of separation of powers issues, because especially when I would talk to career attorneys in the SG's office, it seemed as if they felt far greater allegiance and fidelity to the Supreme Court than they did to the president. Presidents come and go. U.S. Supreme Court justices last for a long time. They're lawyers. They argue in the Supreme Court. You could find them almost really wanting to have the favor of a justice. Their day was made if Justice Rehnquist or Justice Brennan or somebody like that said what a great job they did, far more than caring about what the President of the United States said about them. That does, it seemed to me, raise some interesting separation of powers questions. But again, the justification is it's in their client's best interest, to, as with any attorney, to develop the best relationship they can before the judges before whom they practice. And so there are lots of reasons, I think, that they have such a success rate. But it's notable. I'm happy to ask other questions about the Solicitor General, but I want to turn my talk now a little bit more to appellate advocacy in the United States generally, which is ultimately, in some ways, as you shall see, really a continuing talk about the Solicitor General. I've already told you that information. So now I want to quote that noted legal scholar, Bob Dylan, that the times they are a-changin' in the United States, as it relates to appellate advocacy generally, and also I'll end my talk talking about how things are changing maybe in the Solicitor General's office and what we think about it. When I was doing my interviews for deciding to decide, and I am so sorry, I lost how far I am on time. I have plenty of time. Remember, I can make it seem like an eternity, so don't give me that. Oh, good, okay, thank you. Right. In the last several years, we're having changes in appellate advocacy, as I've already suggested. Oh, I'm sorry. I got lost thinking about time. And when I was interviewing in the court, one of the things that I heard over and over from justices and solicitors general and others was that the quality of appellate advocacy from the states was abysmal. That even though there have been courts for several years who've been very interested in changing notions of federalism in the United States, largely speaking, giving more power back to states, and particularly in the Rehnquist court and even the Berger court that preceded that, and in fact our current court, extraordinary desires to reverse some of the move towards national power. When states' attorneys general would argue before the Supreme Court, they were horrible. Think most states' attorneys general in the United States are elected officials. They're very good politicians, but they're not necessarily good trial lawyers, and they're surely not good appellate lawyers. Even those who were appointed were often appointed for completely different skills than appellate advocacy. And so the quality of representation, at least through the 80s, in the United States by states was terrible. And one of the things that has changed now is that we now have had the development of state solicitors general. That in just a few, in 1988, there were only 8 SGs in the United States at the state level. Now there are at least 29, and they have now all modeled themselves, well, most all of them have modeled themselves on the role of the U.S. Solicitor General. It's a pretty good model if you can pull it off, because high-quality lawyers, repeat player, and so forth and so on. And in fact, the story to tell you is they are pulling it off with a high degree of success. And this was partly a response, as I said, that the court was quite frustrated by the quality of appellate advocacy from the states. But there were also some other factors that were going on, which I'll say a little bit later. To give away the ending of my speech, or the next stop in my speech, we are also developing a far more sophisticated appellate bar that argues in the United States Supreme Court. And these things have gone hand in hand, both with better appellate advocacy at the state level and also with the private bar. Chief Justice Berger was known for complaining about the quality of state advocacy because he cared a lot about federalism issues. It has continued with other justices along these lines with their concerns, and people started getting the message. All of a sudden, there were new groups being formed to help with appellate advocacy by the states, to give them moot courts, for example, before they argue before the Supreme Court. These were things the National Association of State Legal Counsel, other organizations began to develop along those lines. And they started trying to create state SG agencies, but there were lots of problems here. Number one, they didn't have the close relationship with the Supreme Court that you do in Washington, of course. Also, there wasn't the prestige of attracting the best lawyers to the state Solicitor General's office. But that has begun to change in many ways. And others, in addition to the Supreme Court, had noted the general poor quality of appellate advocacy as a general matter in the United States. Let me give you some comments of some judges. One was from Judge Aldersert of the U.S. Court of Appeals for the Third Circuit. He said, you know, appellate advocacy is specialized work. It draws upon talents and skills which are far different from those utilized in other facets of practicing law. Being a good trial lawyer does not mean that you're a qualified appellate advocate. Judge Lawrence Silberman of the Circuit Court of Appeals for D.C. Said that the skills needed for effective appellate advocacy are not always found, indeed perhaps are rarely found in good trial lawyers. And Justice Scalia, in what was understatement for him, if you've ever happened to read some of his opinions, he said not only is the appellate advocate different, but that trial judges are just fundamentally different from appellate judges. And so many of our good counsel in court are trained in the trial area, and we don't have as good appellate bar generally, and they're not meeting the needs of appellate judges. And so, again, the states slowly began to respond. And it's kind of dramatic. I mean, when you think of how long this has been going on, that it wasn't until the 80s or 90s that we came along with these state solicitors general's office. Well, the SG's office in most states is very similar to the U.S. office. Its cases, it is getting on top of controlling the appellate docket. Now, that varies state to state about their authority to do so. But I'm going to talk to you today largely about the state Office of Solicitor General in the state of Texas. Now, if you think Americans are chauvinistic and provincial, you just have to meet a Texan. I mean, it doesn't come more chauvinistic and provincial than we are, even vis-a-vis the United States. And so I am going to talk about that office, but I have a little bit more justification than typical Texas chauvinism. The SG's office in Texas is seen as one of the lead SG offices in terms of the development of state solicitors general. So I don't feel that it's too bad to talk about them. But this office is relatively young. It started in 1999, and there have only been 4 SGs to date. It is currently an office with 22 lawyers. And one notable difference between Texas and the U.S. is that the Texas Solicitor General serves at the pleasure of the Attorney General. It is not subject to legislative confirmation, unlike, of course, the U.S. Solicitor-General. And I'm curious to see, as I'm starting a project, the extent to which that matters. In fact, I should pause and say I have begun a project looking at state solicitors general and trying to understand the differences in the offices, how they work, and so forth. I'm not very far along with that, other than beginning to study the Texas office. And so maybe there'll be another conference in a couple more years in Australia about that. And I thank you. I'd love to come back. But it's interesting because Texas has very rapidly been able to build a strong group of attorneys with lots of experience. They've actually appeared in courts all over the nation. Not only do they argue in the Texas Supreme Court, but they have argued in many federal courts of appeal. And they've conducted numerous arguments in the Fifth Circuit Court of Appeals, which is the federal circuit which Texas is a part of. They've argued in the U.S. Court of Appeals for the Seventh Circuit and the D.C. Circuit. And this is important because the way our judiciary is organized, and you wouldn't normally go to these other circuits unless you had they particularly wanted to hear from you, as I'll have something to say about in a minute. They've even been asked to argue in the North Dakota Supreme Court, and today they have already argued 14 times in the U.S. Supreme Court. Now, again, if you think of how few cases go before the court and how tough it is to get in there, that's a pretty high number to get repeat player abilities in the Supreme Court of the United States. And its influence is coming not only through its argument in court, it's authored numerous briefs and amicus curiae, not only for itself but for other states. For example, it filed an amicus brief on behalf of 17 states in defense of the constitutionality of a state moment of silence laws in the Seventh Circuit. It's also filed an amicus brief on behalf of all 50 states in the United States Supreme Court in Elk Grove United School District versus Newdow. And it filed 2 cases recently in the District of Columbia on the constitutionality of the District of Columbia's ban on handguns, and one of those cases, of which Texas played an important role in the brief of that initial case, led to the landmark Supreme Court ruling that we've just had on the Second Amendment, holding for the very first time in our history, despite things that you've heard from the NRA notwithstanding, that for the first time it held that the Second Amendment does have some individual rights to bear arms. And again, Texas SG's office played some role in that. It also recently argued in a case in the D.C. Circuit, or submitted an amicus brief in the D.C. Circuit on behalf of 50 other states, many other states, the right of President Obama to include prayer and an oath of office that invokes God. If you notice, in my cry of the court, I said, "God save the honorable court." Any use of the word God in the United States today under the First Amendment is a problematic issue. It's now referred to, at least when Justice O'Connor was on the court, as ceremonial deism, but it remains to be seen what this court does. But again, if you want a First Amendment lecture in religion in the United States, have me back. I'd love to come. Now, it's important to note that not only does Texas not only initiate the amicus participation, but in various courts they've invited various courts have invited the Office of Solicitor General to participate in pending cases. Most notably, in October of 2009, the U.S. Supreme Court invited the Office of Solicitor General of Texas to file a brief expressing the views of Texas, and that is the first, and to this date only, such request of its kind. Similarly to a state Solicitor General's office. Similarly, the Texas Supreme Court has recently established a new practice of inviting the Office of Solicitor General to express the views of the state of Texas in certain pending cases when they've chosen not to be a part of the case. And this is apparently modeled on the U.S. Supreme Court as well, where the Supreme Court often calls for the views of the Solicitor General. Now, so they're getting repeat play practice. They've taken serious appellate, getting lawyers that do appellate advocacy. They're working very hard at this. But it's also a matter of recruitment. And so like the federal government, they are now starting to recruit some of the top law graduates in the nation. 45 of the attorneys who serve now there have brought experience from handling many very important appeals in the state. Several of the members of that office, and there are 22 in the office now, several previously served as partners in very prestigious law firms around the state. Others have been served in important positions in the federal government, including the Federal Trade Commission and as lawyers in the Justice Department. Dozens of these employees have clerked for state and federal judges, including 10 on the Texas Supreme Court and 11 on the U.S. Court of Appeals for the Fifth Circuit, and others on other federal courts and appeals and district courts throughout the nation. And 4 of the attorneys have clerked on the U.S. Supreme Court. And I assume you know this, but to clerk for a circuit court of appeals in the United States is one of the most sought-after positions for the best law students in the nation. It is the ticket to the big law firms around the country, New York, Washington, Dallas, Houston. It's the ticket into the Justice Department, and there are very few district courts of appeals, judges that need federal clerks. And to become a U.S. Supreme Court clerk, you almost have to be struck by lightning. And so all of a sudden, within a very few years, they're now recruiting this top flight of lawyers. And I must say, at salaries that, they aren't as low as poor professors, but they are nowhere comparable to what they could make in the private bar or other places. And yet, because of the enjoyment of the work, because of the importance of the work, which I know you understand, they're able to recruit great talent to do it, even at the cost of all sorts of abilities to make money. So a dramatic change with the state solicitors general. Now I want to turn to the private bar for just a moment. There's an anecdote that's often told that the great Professor Moore, the civil procedure guru, was once in the United States Supreme Court making an argument, and he was making a subsidiary point to the justices that was inconsistent with the famous treatise that he had written on civil procedure, and one of those justices pointed that out to him, and Professor Moore is reported to have said, well, you know, I have found that the better I am paid, the better I think. And so now let's talk a little bit about the private bar. If you happen to be watching the confirmation hearings of soon-to-become Chief Justice John Roberts, one of the things you would have seen and heard talked about, or maybe it was reported on the news afterwards, is how many times he had appeared before the U.S. Supreme Court and how good he was as a lawyer before the court. And I'll resist making many comments on other remarks that he made about, like, the role of a judge is only that of an umpire and other things. But he was very smooth in this, and people were talking about how often he had appeared and how he would be ready to step into the role of a Supreme Court justice. What might be surprising to most people hearing this is to know how rare it is for someone to have argued before the Supreme Court as a private counsel. Most lawyers, though we have thousands admitted to the Supreme Court bar, most people will never get close to the United States Supreme Court to make an argument. And those who do, it's a once-in-a-lifetime opportunity to be a repeat player, not being a government lawyer, or maybe not being from someone like the NAACP Legal Defense Fund during the Civil Rights struggle. It would be extraordinarily rare to argue more than one case. A few lawyers from the private bar had done it. Historically, it was quite common where we had people like Daniel Webster and William Pickney and Francis Scott Key, the guy who wrote the Star-Spangled Banner. He's a better lawyer than songwriter, who would engage in oral argument. But that was in an earlier time, early 19th century, where Washington was a swamp. You couldn't get there from New York and Boston, and let alone Atlanta. And so there were some people who did argue from, particularly in that area more frequently. Oral argument went on for several days. But as we move to modern times, very few people from the private bar had that type of experience. And yet, the times they are changing. And as a political scientist, sometimes this story bothers me a little bit because we like to systematize everything and see forces in society and so forth and so on. And it makes us sometimes a little bit uncomfortable when we just tell stories about individuals. But in some ways, this is a beginning story about an individual. Okay, 5 minutes? Okay, thank you. I can do that quite easily. After Rex Lee was Ronald Reagan's first Solicitor General, he left the government and moved to one of the big law firms in Chicago called Sidley & Austin to set up an appellate Supreme Court practice. most big law firms in the United States saw no economic advantage. I mean, there wasn't enough work. Why would you have a specialized appellate division? But he went there. The story is, in the first term, he got picked to argue 2 cases in the Supreme Court, won them. The next term, he got to argue several more in the Supreme Court and won them. And there was an important thing about his clients. These were not pro bono clients. These were not major constitutional issues. He was taking cases for major corporations and business interests and getting to argue with some frequency in the Supreme Court. Very soon after, other law firms in Chicago and then a few other cities started developing big-time Supreme Court legal practices, which in some sense doesn't make much sense if you don't get to argue a lot in the Supreme Court, but of course it brings a prestige to your firm. There's other business to help your clients write briefs to oppose the people who oppose them from getting into the Supreme Court. And so all of a sudden we've had this development of this very elite bar. And one of the stories about that after Rex Lee was John Roberts and other people who are now being recruited into private law firms, many of whom come, by the way, as former employees in the Solicitor-General's office. So some of the younger attorneys are leaving and going into private practice. Let me run through just a couple of slides real quickly to show you. Well, let me just tell you a quick story here, and I'll summarize this. These are the cases filed before the Supreme Court, and you'll see the number in 2009 was 8,159. But we've had quite a dramatic change in what has happened. In the 1980s, there were an average of about 150 to 160 signed opinions in the Supreme Court. And starting in the late 1980s, the docket of the Supreme Court has shrunk dramatically. And to now, in 2009, from a high of about 160 cases, the Supreme Court is only offering 73 signed opinions. So the court has had a lot. It's reduced its workload dramatically. And what that has meant, remember my figures, the Solicitor General is arguing 75 to 80% of the cases. State Solicitor General's now acceptance rate, with the standard being 3%, is up to 24% of their petitions of certiorari are getting granted. And 44% of the cases, when states are supporting cert with an amicus, are getting accepted. And I don't have time to show you the figures, but all of a sudden this elite private bar's percentages of cases that they represent, people who are repeat players, are getting, their percentages are going up almost every term of the number of cases that they're getting to argue in the Supreme Court. So here's the overall picture. And I don't get to raise so many of the provocative questions, I guess, with this. And that is, we have a shrinking Supreme Court docket that's controversial in and of itself. And yet the number of people who are arguing before the Supreme Court is a very small handful of people. Always it's been the case with the SG, but it's now the case with states, and it's now with this private bar, and that it does seem to raise, in the eyes of some real normative questions. Of course, it's a good thing to always have better appellate advocacy. And if we assume it's only about the quality of appellate advocacy, then there's nothing to worry about. But when you understand that the court has reduced its caseload, and the private bar is overwhelmingly representing certain sorts of people who can pay extraordinary fees to carry a case. It can cost $100,000 just to get a petition for certiorari in an easy case, and legal fees and so forth. In complicated cases, it's more. It does seem to be a normative question of, in the name of better appellate advocacy, is there something about, and who the repeat players are, is there something that we ought to be worrying about normatively? And so one thing that has come across as a good, better advocacy, may have also other kind of normative implications as well. 1 minute to end with that, and I will just say, so I don't know if there's anything to be learned about what's going on to the United States situation, but it does seem to suggest that as a political scientist, the idea of who is being represented in court, and the nature of the governments having such a domineering position in the Supreme Court for many good reasons, but for other reasons, when our courts become aligned with our Justice Department and different sorts of things, there does seem to me to be potential reasons to worry. And thank you very much. Let me just say thanks to Patrick again for broadening this to a comparative interest as well. It is the hot thing in the United States to, at least in the academic world, for us to become less provincial and to try and bring views from the outside. And I know you're doing that a lot through this center. And I appreciate the learning I get, and I hope it's of advantage to you and your center as well. So thank you.
For more information, visit bond.edu.au/iTunesU.